Good morning, everyone. This is Daisy Glassburn, Chair of the Board of Real Estate Appraisers. Today is September 4th, 2025, and the time is 9:01. I now call this public meeting to order and ask the Division Director to conduct roll call.
Daisy Glassburn,
Here.
Valerie Bartel,
Here.
Brent Goff,
Here.
Clint Taylor,
Here.
Rob Stylo and Darius Wise are going to be absent from this meeting, and you have a brand new member. Her name is Bessie Chachas, and Doreen is trying to track her down, but you do have enough to conduct a meeting so far.
Okay. Our next item is to approve the meeting minutes from the July 10th, 2025 meeting. Do I have a motion to approve the meeting minutes?
I'll make a motion.
Do I have a second?
It's Clint Taylor. I will second.
Any discussion? Okay, hearing no further discussion, all in favor say aye.
Aye.
Aye. All opposed, no. The motion passes. Next, we will move on to policy matters. And Marcia?
So, board members, today we are joined by two policy managers from the appraisal subcommittee, Allison Nesper and Johnny Stewart. They will be conducting a review of your program later this month, but I will turn it over to them to address the board.
Good morning, everyone, and thank you so much for allowing us to observe your meeting. Our title is now program managers instead of policy managers, to be a bit more descriptive of what we actually do. So there are currently 5 of us with the appraisal subcommittee, and Johnny Stewart will be coming to Denver with me later this month. So the appraisal subcommittee was created under Title 11 of the Financial Institutions Reform, Recovery, and Enforcement Act of 1989 to provide federal oversight of state appraiser and appraisal management company regulatory programs and a monitoring framework for the Appraisal Foundation and the Federal Financial Institutions regulatory agencies in their roles to protect federal financial and public policy interests in real estate appraisals utilized in federally related transactions. So the ASC itself, the Appraisal Subcommittee, is a federal agency. It includes 15 staff members and a 7-member board. Those board members come from the Board of Governors of the Federal Reserve System, the FDIC, the Office of the Comptroller of the Currency, the National Credit Union Administration, the Bureau of Consumer Financial Protection, the Federal Housing Agency, and the Department of Housing and Urban Development. So Title 11 itself, the legislation requires that the appraisal subcommittee monitor the state's regulation of appraisers and appraisal management companies, monitor the appraisal foundation's Title 11 related duties, award grants to states and to the appraisal foundation, develop and maintain a complaint referral hotline, maintain a national registry of appraisers and appraisal management companies, and that has both a private and a side that's open to the general public and a side that's open only to regulators. And to recognize the Appraisal Foundation as the organization that determines national standards of practice and qualification for appraisers. So the Appraisal Foundation does that through the Appraisal Standards Board, which sets the uniform standards of professional appraisal practice, and the Appraiser Qualifications Board, which sets the criteria for appraisers. In order to monitor state agencies, the appraisal subcommittee conducts compliance reviews. These are typically on a biannual basis. Prior to the review, we send a letter to the state requesting specific documentation. Once that's received, we review that and request specific application, enforcement, and education files to be viewed while we're on site. We also, while we're on site, meet with staff, review the files selected, and answer questions that staff may have, provide some initial observations from what we've seen. After the site visit, a preliminary letter is sent to the state that outlines the findings of the compliance review. That is not a public record. At that point, the state has 60 days to respond to that letter, although a response is not required, and we're certainly happy to receive that faster than 60 days, but you have a maximum of 60. If a response is received, it's reviewed, and that information is taken into consideration when drafting the final report, letter, and rating. The final report, letter, and rating are public records. The ratings are excellent, good, needs improvement, not satisfactory, and poor. A state's next review cycle is based on its latest compliance review findings. For an excellent or good finding, a state remains on a 2-year review cycle. Needs improvement moves the state to a 2-year review cycle with additional monitoring. A not satisfactory moves a state to a 1-year review cycle, and a poor would mean continuous monitoring. So to ensure compliance, there are 12 policy statements. 7 of those regard the Appraiser regulatory program. They cover temporary statutes, regulations, policies, and procedures, temporary practice, how the state populates the Appraiser registry, the application process, reciprocity, education, and enforcement. Then there are 3 more policy statements that apply to the AMC regulatory programs and deal with statutes, regulations, policies, and procedures, the AMC registry, and enforcement and implementation of the program, but we're pretty much past that stage with all states. The last policy statement is regarding interim sanctions. Title 11 grants the ASC authority to impose sanctions on a state that fails to have an effective appraiser or AMC program. An ASC finding of poor on the compliance review report issued to a state at the conclusion of an ASC compliance review may trigger an analysis by the ASC for potential interim sanctions. And it does provide for an opportunity to be heard or correct conditions. So these documents, the policy statements, Title 11 itself, those can all be found on the Appraisal Subcommittee's website, asc.gov, or you can contact me directly if you would like me to provide you with those PDFs or point you to them. Does anyone have questions about why we'll be showing up and what we'll be doing?
Allison, this is Brent Goff. I had a question about how many states earned the excellent versus the good. Do you have a beat on that?
It's a little hard to tell because some of the states we are currently in the process of reviewing had not been reviewed since COVID, since they had a state offsite assessment, which was not rated. So some of them were going back almost 4 years since they had had a review. Johnny, would you say maybe 3 states or so have excellence on both programs. And then there are some who have excellent ratings on one program and a good rating on their other, either appraiser or appraisal management company. Does
Yeah,
that,
I'd say in a typical year, a handful, fewer than 5 would receive excellence, either in one program or both. The majority receive goods, although if you look at recent ratings, there have been a few more needs improvement, and we think that is largely due to COVID and not having reviews and not staff being kept up to date as to the requirements that they're supposed to maintain. But majority
staff
receive,
turnover
yeah.
as well?
Thank you.
You're welcome. So yes, Colorado can be very proud of the fact that the last ratings were excellent. If that's all,
So board members, the only other item for policy matters is items that you'd like to see on your agenda for the next meeting. And we had deferred discussion of 11.3 because the AG wanted to kind of advise you some more on that rule. So I know that 11.3, the proposed revisions will be on your November agenda. Is there anything else that you would like to see?
Not from me.
I don't have anything.
Okay,
I don't have anything else to add.
so that moves us into the citizen participation period.
All righty. Any person may bring concerns about matters not on the agenda before the board. Speakers are asked to limit remarks to 2 minutes unless granted more time. The board may also allow public comment on agenda items. Is there anyone signed up to speak?
Thank you, Madam Chair. As the chair indicated, any individual that would like to address the board, please understand that the citizen participation period is not to address the specific investigatory matters on today's agenda, but that members of the public and members of the public should not bring those to the matters forward now. But speakers are again requested to limit their comments to about 2 minutes. And if you would like to address the board, I would ask that you please select the raise hand icon, which you can be located in the Zoom platform tool menu, generally located at the bottom of the screen, and then we could unmute you. So board members, if we can give it a moment to see if anyone would like to raise their hand, and then I'll let you know. However, not seeing any, I'll pass it back to you, Madam Chair, and for the next matters. Thank you.
Thanks, David. Thanks. We'll now move on to complaint investigations. I think Garrett.
Thank you, Madam Chair. Good morning, board members. The first complaint matter A is number 2025930. The complainant's allegation that the respondent did not have the appropriate level of licensure to appraise the subject property appears to have merit. The respondent is a licensed appraiser and his opinion of market value for the subject was $1,876,000. This amount was substantially higher than a licensed appraiser is allowed to appraise. In reviewing the report and work file, there appeared to have been potential use PAP violations of the scope of work rule, ethics rule, competency rule, record keeping rule, and multiple violations of standard rules 1 and 2, as well as board rules and state statutes. The respondent appeared to have inadequately researched, analyzed, and documented the neighborhood, market area, and the current market conditions. The report did not contain the specific criteria used to determine the comparable properties, nor was there sufficient commentary concerning the selection of the comparable sales. There is insufficient commentary and documented support for the adjustments in the sales comparison approach, and also it appeared that neither the cost or income approaches were considered. Possible violations include 1210-613-1B, 1210-613-1F, 1210-613-1G, 1210-613-1H, 1210-613-1K, ethics rule violation, competency rule, scope of work rule, and record keeping rule, as well as standard rules 1 and 2. Recommendation for discipline includes final agency order, a fine of $2,000, work product review, 4 appraisals in 2 months, and then under the coursework, there's a correction to be made, board members. That should read National USPAP course 15 hours, and then residential sales comparison and income approach. In addition to that, we recommend a practice restriction prohibiting appraisal of non-complex 1 to 4 unit residential properties having a transaction value equal to or in excess of $1 million, or complex 1 to 4 unit residential properties having a transaction value equal to or in excess of $400,000 prior to upgrading their credential to certified residential appraiser or certified general appraiser. And Investigator Walker is here to answer your questions.
I just have a question. How would he upgrade his license if he's having a practice restriction? I mean, I guess he could do it to certified residential.
That's right, yeah.
Okay.
What we would do is, there's already regulations in place that prohibit those appraisals in excess of those amounts, but we would codify that in this stipulation. We would document that in the stipulation. So if that practice continued, that would also represent a STIP violation.
But he could do this with a mentor then? Or he can't do it at all?
Well, if he had somebody with a higher credential that was signing the appraisals, then he could. But I don't think that that's the business model from what I've been told from Jared and the investigator.
Okay. I just kind of want to understand that last part.
Ultimately, we would like him to practice within the limits of his license.
Right.
And if he wants to do certified residential, he needs to upgrade to be a certified residential.
Yes.
Did he mention that he was planning on upgrading, or was he going to continue as a licensed appraiser?
I believe he, in his response letter, he's basically said, I will upgrade at some point if required to, essentially.
Okay, thank you.
Yeah, in the response letter, it referenced I believe, a July 11th date for applying for the upgraded credential. That has not yet occurred, and perhaps the licensee is waiting for the discussion of the board members here before making that application.
Jared, this is Daisy. Is the final agency order, is there public censure along with that, or?
No, right now our recommendation is simply for a final agency order. Through your discussions, you have the ability to upgrade that to include public censure or even downgrade it to diversion as you feel appropriate.
Mr.
Do I have a
Walker,
motion? Oh, go ahead.
I have a question for Mr. Walker. In your investigation, did you find that you just didn't know about the transaction value, or was he trying to skirt around that issue?
He knew that there were $1 million limits on the transaction value. His reading of the statute was the transaction value was like a loan amount as opposed to opinion of value of market value. So basically he said, I didn't know. He also said that, if he did loan appraisals with a loan, he would actually call up and ask them to see if the loan amount was under $1 million. So he knew there was limitations on an AL license, whether or not it was intentionally, if there's potential workaround, only he will know.
Yeah, this is Zach. He was reading the statutes in a very creative way, while omitting relevant parts of the statute in his analysis, basically.
Okay. That's what I was trying to figure out was this a act of omission I just didn't know, or was it purposeful? I don't know if there's an answer to that.
There's a definition of transaction value in the Colorado Real Estate Manual, which is not hard to find. I found it in about 2 minutes.
Okay. Thank you.
My concern is that a large degree his clientele and what he does for his general work is in the court systems, litigation, and attested that he was very well known in the community for doing that. And I would just like to know any other board members' thoughts on the possibility of public censure, considering those things.
I would have to agree. This is Clint Taylor with what Daisy is saying. That's where my head is going. Is there is a concern that there is a potential misinterpretation of what he is thinking from his license standpoint, and if there's prior reports that have been done with this methodology and thinking, there is a difference between license and certified, and so that is important to know.
So was he advertising that he did all sorts of residential properties?
I believe in the report, it was included that he has testified in numerous jurisdictions around the Denver metro area, and that he specialized in mountain and acreage properties. So that would lead one to believe most of those transactions would be above $1 million.
I'm good with the public censure. I think that's a good addition, Daisy.
This is Clint Taylor. I'd second that recommendation if we're going that route.
Does somebody want to make an official motion for that?
This is Clinton Taylor. I'll make a motion for public censure.
This is Brent Goff. I'll second that.
So I just want to be real quickly. Are you otherwise accepting the rest of the boards or the rest of the division's recommendations and then adding public censure? Is that the?
Yes.
Okay.
Yeah, I would agree. Yeah.
Sorry about that, Zach.
That's okay. I just, lawyers have a lot of neuroses.
We appreciate it. Okay, I have a motion and a second. Is there any further discussion? Okay. Hearing no further discussion, all those in favor say aye. Aye.
Aye.
All those opposed say no. The motion passes. Let's see, the next complaint matter will move to 2025-550. Is that correct, Gary?
That is correct. Complaint matter B is number 2025550. It was alleged the respondent engaged in the business of an appraisal management company without a license issued by the state of Colorado. The respondent's CEO insisted it was simply an oversight, believing the company was already licensed. He later stated the company had applied for a license prior to sending the assignment order. The investigation revealed the respondent was not licensed prior to ordering and processing an appraisal report. It also became apparent the respondent had not submitted an application for a license until after the appraiser requested their AMC credential number. Possible violations include 1210-614-1A2, 1210-614-10, and 1210-617-1. We do not have a recommendation for you, and that is because this is a bit of a unique situation. In the past, we've had situations where an AMC has issued a order for an appraiser after submitting their license application, but before getting it finally approved. Although that was the assertion of the respondent in this case, it turns out that it doesn't appear that they had submitted their application until after they had already ordered the appraisal. So due to that inconsistency and that inaccuracy, we are bringing it to you for discussion about what would be appropriate discipline.
This is Valerie Bartel. Would we ever know if they had submitted other orders prior to this, but for the fact that this appraiser had asked for the AMC number?
Most likely not.
Okay.
This is Clint Taylor. This is something that we could potentially request and from the AMC to verify if there's been any prior orders that went out, or was it just this single action or single order? In my opinion, when you submit an application for anything, you're waiting for that approval before you go and move forward, especially in when it's with a state and also engaging those appraisers. So I applaud that appraiser for following up and making this complaint. As an AMC myself, that's how I would do it. I would make sure that all parties are aware that we're entering a state and wait for that correspondence coming back saying approved before you do any further business. So as far as any type of discipline, which I think that's what you're asking the board to discuss and come up with an idea, correct?
That's correct.
It's hard to just throw a dollar amount, or it's not like you can say there's some classes you need to take or review some documents maybe. As far as rules, so this is a little bit of uncharted territory. So I'm gonna have to kind of ponder on that one, and I don't know how we want to do that, or if that's something we need to go into like executive session on or something to discuss from a legality standpoint.
I guess
Garrett,
oh, go ahead.
Oh, go ahead. Garrett, I was wondering, previous to the example that you had said before, what were the ramifications in those situations or the options from those?
So in some of those situations, we've addressed it with an informal letter of concern, just reminding them of their license requirement and the importance of the timeliness. Again, in this case, it seems like maybe there's some aggravating factors that we would want you to consider. And to the extent that you feel it's appropriate as a factor to consider, this is also an AMC that I believe is licensed in 18 states. And so discipline imposed as a result of this matter could potentially result in discipline in those other jurisdictions as well.
Okay. Valerie, were you wanting to say something?
I had the exact same question.
Okay.
Can I add something? So from my experience, there's an appraisal from an AMC standpoint. There's certain states require it, but every year you have to do a registry fee for how many appraisers you've engaged in, and there's a fee that's paid. So that's a little bit something different. However, if you happen to miss something like that, and the state then reaches back out and says, "Hey, you didn't do this," a lot of times what'll happen is your AMC license will be put on pause until it's rectified, and then it gets presented to the board. This is kind of a similar situation, it's a similar situation, but a different kind of topic. But I know that the outcome of something like that typically is a fine. In the board typically will provide that number back to the AMC, and then once the matter is rectified, then you're active again. I don't know if that's something, and again, every state has it different, but I don't know if that is something that we may want to consider, and I can explain more on that if necessary, but it's an idea. Does that make sense? I'm sorry.
Yeah, what were some of the fees that you've seen, or have you seen?
Well, again, it comes down to the states. I know that if, it can go like a dollar amount per day past the that can be thrown towards the AMC if they have not rectified it or answered, or it's just a flat fee. Like, say, for instance, I'm just throwing a random number out there. It could be, a $2,000 fine due to the lack of responsibility of, reporting your annual fee on time. It could be something like that on top of the regular fee that you would pay. So there is something like that. Again, this isn't in regards to the annual fee. This is in regards to just registering on time in general. So the fact that this AMC chose to act without having a license is a major concern. And I don't feel like it's something that we can just send a letter saying, hey, next time you go into a state, make sure you get your approval before conducting business. I mean, if they're in, it's one thing if this is your third state, but they're in 18 states. So I feel like there's a process there that they should have had mastered yet. And, it is a concern to be representing yourself as a business and conducting business in a state without approval. I think that is rather concerning and does bring up, is there other states they've done that in? Putting the cart before the horse is a major issue in this context, in my opinion.
This is Brett Goff. I'd have to agree. I would just think I'm 30 miles from the Utah border, and if I traveled to Moab to do an appraisal and I didn't have my license nailed down in the state of Utah and they caught me, regardless of my story, I think a fine would be coming. And if an individual appraiser has to think through that business process, these guys, due to the volume of their work, have an even greater onus on them to uphold the public trust and not do business in a state where they're not licensed. So I think a $2,000 fine would be appropriate and would get their attention.
And in addition, sorry,
ahead.
Daisy. One last thing. In addition, from I would say a profit margin that an appraisal management company makes on per order, I think that dollar amount, we could say between 1,500, 2,000, would be a substantial, I guess it's letting them know that, hey, we mean business. This is a serious matter. If it was just like $500, they're like, whatever, but I think, that would cover potentially the profits that they made on how many orders they conducted without being licensed, right? Whether or not they did it or not. So I think that what Bryant is saying is fair.
Did either one of you want to make a motion then on that?
I'll do it. This is board member Brett Goff. I'd like to make a motion that the discipline imposed would be a $2,000 fine for this appraisal management company.
Okay, I have a motion. Do I have a second?
This is Valerie Bartel. I'll second.
I have a motion and a second. Is there any further discussion? Okay, hearing no further discussion. All those in favor say aye.
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 All those opposed say no. The motion passes. And we can move on to complaint matter C.
Thank you, board members. The final complaint matter C is number 2025822. The complainant's allegation that the respondent failed to properly analyze the subject's highest and best use did not appear to have merit, but the allegation of improperly considering the mobile home as real property was identified as a concern during the investigation. In reviewing the report and work file, there appeared to have been potential use PAP violations of the scope of work rule, ethics rule, competency rule, record keeping rule, and multiple violations of standard rules 1 and 2, as well as state statutes. The respondent appeared to have inadequately researched, analyzed, and documented the neighborhood market area and the current market conditions. The report did not contain the specific criteria used to determine comparable properties, nor was there sufficient commentary concerning the selection of the comparable sales. There was insufficient commentary and documented support for the adjustments in the sales comparison approach. It did not appear that the cost or income approach were actually considered. Possible violations include 1210-613 1B, 12-613 1G, 1210-613 1G, ethics rule, competency rule, scope of work rule, record keeping rule, standard rules 1 and 2. Recommendations for discipline include diversion, a fine of $1,000, and coursework in comparative analysis and or supporting adjustments, residential sales comparison and income approaches, the 15-hour national use PAP course, and reliable record keeping. And again, Investigator Walker is here to answer your questions.
Mr. Walker, this is Brett Goff. It seemed to me that the water, irrigation water, was an issue in the report. His response, it was kind of ironic. It said, determining the contributory value of irrigation water is complex. So he's admitting it's a complex facet to an appraisal assignment, but he's a licensed appraiser. So would it be appropriate to add a course in water law or water appraisal to the coursework recommendation? What do you think about?
I think that would be up to Garrett to make that sort of recommendation. I don't make any sort of recommendations.
Okay. It just seems to me if he's tied around the fence post about water shares versus real property versus personal property and that kind of thing, it'd be advantageous for him to gain competency through the coursework rather than another appraisal out there where he doesn't know what he's doing.
We could add that to the coursework if you wanted to make that motion to add that as part of the disciplinary recommendation.
Okay. Maybe a 7-hour course in water appraisal or water law would be my recommendation.
Is that typically the length of courses like that? There's availability for, I suppose he could double up if it wasn't long enough. Sometimes the availability of coursework doesn't match.
Yeah, I just took one that was a day long. It was excellent. So.
Okay.
I mean, would we make it like just generally a coursework relating to water rights in Colorado, or that way he could find something?
Yeah.
Okay.
So there's some approved providers on the, I think on the Board of Appraisers website that offer that course. I'd point them to that.
Okay.
Water law, water rights appraisal course. I don't want to give the provider name because I don't want to give them a plug, but they do a lot of farm appraisals.
Okay, but there are multiple avenues that he could probably find and take for this, is what you're saying.
Right.
Yeah. Okay.
Brent, did you want to make that motion then? Or
I will. I'd like to make a motion that we adopt the recommendation, but also add a 7-hour water law or water appraisal course to the discipline.
Okay, I have a motion. Do I have a second?
I will second. This is Valerie Bartel.
I have a motion and a second. Is there any further discussion? Okay, hearing no further discussion. All those in favor say aye. Aye.
Aye.
Aye.
All those opposed say no. The motion passes. Let's see, we'll move to licensing matters, which it looks like there is none, and it looks like there's also no EFT matters. If there's nothing, is there anything else, Marcia, that you have?
No, there isn't.
Okay. Oh, Zach, go
One
ahead.
thing real quick. I just wanted to say it's been really great being your general counsel for the last 2 years. Due to some changes in our office, I'm going to be stepping into the role of the general counsel for the Independent Ethics Commission, and so Karen Safran going forward is going to be your new general counsel. Karen's on this call. I think most of you have met her before, but you're in capable hands, and I'll still be around in the real estate unit for litigation and for any assistance needed. But I just wanted to say thank you. I really loved my time on this board.
Thank you, Zach.
Thank you so much, Zach. I appreciate you.
We'll miss you, Zach. But
Yeah.
good luck.
I should say-
Yeah,
I guess-
absolutely.
Yeah, I guess I should say hi, and I'm going to do my best to hold up the standards that Zach set, or exceed them if need be.
Nice.
Yeah,
Welcome,
yeah,
Karen.
just
Thank
teasing.
you. Okay, we've reached the end of today's agenda then. Do I have a motion to adjourn the meeting?
This is Brett Goff. I make a motion that the meeting is adjourned.
Okay, do I have a second?
This is Clint Taylor. I second that motion.
Okay, all those in favor say aye.
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 Those opposed say no. Okay, thank you guys. Our next meeting is November 6th at 9 a.m. We'll see you then.
Thank you.
Thank you.
Thank you, board
Cheers.
members.
Thank you.